Hello, Kathy Beatty here with Divorce Support Anonymous. I want to talk to you today about how does divorce mediation work. In the state of Michigan, all divorce cases in our county are sent to mediation. In most states and most counties, that is a preferred method because it really clears out the courts. It allows the individuals to be more empowered to make their own decisions on how the rest of their life is going to go. So it's a very common practice that you would go to mediation as you're going through divorce. As with many issues of divorce, it's an area you've never been through before. So it's fearful. You are fearful because you don't know what's going to happen. So I want to put your mind at ease a little bit to tell you the process. Now I'm going to share with you how I conduct my mediations because I am a domestic mediator. It may be a bit different, but these are the basics that you should plan on in your mediation. So the first step that I'm going to mention is a domestic violence screening. You're going to go through, and this may be just a phone call prior to the mediation. Typically it is. I can't imagine wasting the time of coming all together and then doing it. It should be done prior. The domestic violence screening is really to make sure that both parties are on level playing field. If you are incredibly intimidated by your soon-to-be former spouse, you are not going to be good in mediation. Although the majority will have your attorneys with you, this really is a time for you to be empowered to make those decisions, to divide the assets, to divide the debts, to determine co-parenting. All of the issues in divorce can be settled completely in mediation. So we have to know, are you competent to mediate? Can you think for yourself? Are you is there an imbalance of power? Again, do you feel intimidated by this person? Now, what happens for some of the mediations, we always start in the same room when we go into the mediation. However, sometimes things get a little too emotional, too heated, and we will separate the parties. So I will do a shuttle mediation. So I will go to one room, I will listen to their proposal, I will take it to the other room, I will convey the information. It's back and forth. Not as efficient, but it can happen. And I have had those from the beginning who determine they want to be separate. It's not as efficient. I don't recommend it to start that way, but it does happen. So again, we want that domestic violence screening to know that you are competent to stand up and to speak for yourself. Everybody going through mediation is a bit fearful and a bit insecure because they've never been in this environment before. That's not what I'm talking about. I'm talking about being threatened by your spouse, maybe before or after. So we just want to make sure that you are on level playing ground when you're going through the mediation. Once that is out of the way, I am going to go into individual rooms. You're going to be in one room with your attorney. The other party is going to be in their room with their attorney. I'm going to I always meet with the plaintiff, the person who filed for divorce first. So I'm going to go in, I'm going to sit down, I'm going to get a feel for what's going on. This helps me to determine what exactly I'm dealing with. Many times beforehand, I will have opinions or briefs from the attorneys, and I'll review that to give the facts, to see what people want. But really, for me, it helps that I meet with the parties individually first. And I'll ask, what is it you want to get resolved today? And I'll take a lot of notes and use those throughout the mediation. So once I have spoken with you, I'll go over to the other side and I'll spend probably 20 minutes to half an hour talking with them and getting what it is they want to get resolved today. So I've got this picture in my mind of what we need to settle. So at that point, I bring the parties into one conference room. So I'm going to have the individuals, well, I'm calling them parties. That's just the legal term that we use. So the parties are going to be sitting beside me. Beside them are going to be their attorneys. The attorneys are there to really coach and to protect the individuals. They're not there to run the mediation. This is your time to deal with all of the issues of divorce. Now, I always allow people to have timeouts, and that's part of my opening statement. So a mediator is going to spend about 15-20 minutes to tell you how this mediation is going to be run. So you don't even have to say anything when you come together for a while. Give you a minute to get your bearings. So I'm going to do an opening statement. My opening statement, I have, a whole list that I go through to make sure that I've covered the information that I need to. What I need to determine in my opening statement is that I am an impartial person here. I'm not siding with either one of you. I'm not making judgment for either one of you. And that's important because we want a neutral party who's going to lead the mediation. That's my role. I'm in charge of the process of mediation. I'm not going to advise. I may put creative ideas out on the table for us to discuss. That's always helpful. But I'm not going to advise. And you're not there to convince me of anything. Although people try, it doesn't matter. I don't want to say it doesn't matter to me because it matters to me. But it's not important what I think or what I'm feeling about what you're doing here. You don't have to convince me. So I've got a whole list of things that I speak about. The benefits of mediation, that you're there so the courts don't determine how the rest of your life is going to go. Again, this is your opportunity. I'm impartial. How I know your attorneys. If I know the attorneys from past mediations, I will state that. If I've spoken with them at an event or a training or been to trainings with them, I will mention that. Why is that important? I want you to know as a participant that I'm not buddies with the attorneys here. I don't owe them any favors. And that, in fact, I say that. I don't owe your attorneys any favors. I'm a neutral party. My integrity is very important to me, so I want to remain neutral. I always tell them you can have a timeout. And please know this, as I mentioned earlier, you need a timeout. My line is, if you need a cigarette break and you've never smoked a cigarette a day in your life, today may be the day to do it. If you need a timeout to consult with your attorney, we take it. Even if I'm speaking in mid-sentence, you can say, I want a timeout. We call it a caucus. At any time to speak with your attorney, to get a breath of fresh air, to think, to make a phone call, to pray, whatever you need to do, a timeout. And the reason that's important is because this is not a pressurized process. I'm not here to force you to make any decision. I want you to think clearly for all of the implications that are going to be there for your decision. Confidentiality, totally confidential. Why that's important is we can be creative here. We can throw ideas out on the table, and you cannot take it into the courtroom and say, but you said in mediation, it doesn't work that way. We want this creative, safe space that we can try to work out and hammer out all the details, all the assets, all the debts, co-parenting, child support, spousal support, all of those things. Our goal is a written agreement. The written agreement is legally binding. Let's see. Deal in the facts. That's always an important line that I state. Deal with facts, because unfortunately, your marriage relationship has now come down to a business transaction. So you need your best business sense hat on, and you need to deal in the facts. And you are not there. Another line that I have is you're not there to punish the other person. This is not the place. You are paying your attorneys and you're paying me. In most cases, even though I do quite a bit of volunteer work through the Dispute Resolution Center here in Grand Rapids, you are paying a lot of money. This is not the place to have a therapy session. Realizing sometimes apologies need to be made. Things do tend to go there, but please know we want to be as efficient as we can with this time and in this process. So that's the opening statement that I state to kind of set the tone. We're not going to interrupt each other. We're going to be civil. All of those rules. And then for me, actually, when I'm doing Zoom meetings and doing mediations, I have behind my board here a whiteboard. And I will go through and agree and make sure that we agree on the numbers. Why do I do this? Because if you're going to divide a house, you need to know what is the house worth. So you need appraisals. And many times, which frustrates me, people will come into mediation and the attorneys have not told their clients, we have to have an appraisal on the home unless the both of you agree on a value from the SEB or, whatever reason, however you've come about it, that you agree on a number, that's fine. But typically, especially today with all of the, the housing costs are so wacky. They're increasing so steadily and so high. You want that appraisal. And then you're going to take the equity of the home and work on that division. So it's real important that we have those numbers to begin with. We can't guess and say, well, whatever it praises, we'll divide. No, it doesn't work that way. Courts don't like that. We have to have definitive numbers. So that's your prep work before, and that's why I created the workbook Preparing for Mediation, which is free upon request. And just connect with me and ask for it. I will send it to you. It helps guide you through that process. So agreement of numbers, really, really important. And that can take an hour or so by the time we go through. This could be the value of anything, a cottage, a boat, motorcycles, anything that has higher value, and personal property too. Again, hopefully you've prepared this all before you go into mediation, but it's really important. And I have found over the many years that I've been mediating, this is really critical and will make or break a mediation. So we've got to have agreement of the numbers from both parties. And then I'm going to begin with a win. I'm going to look for something small that we can agree on, just to kind of start the momentum. Maybe it's a motorcycle that's valued $10,000. You know you don't want it. You know your spouse wants it. So at that point, that could be a win. There's nothing to fight over. We agree on, because we have a green book or we have a number, the value of the motorcycle. You know you don't want it. You know he wants it. But you still have, if it's worth $10,000, you still have $5,000 on your side of the ledger to whether he pays you out. You can work that out. So I want to start with a small win, just to kind of get the momentum, to get the feel of what a mediation is like. The moving party is the one who filed, and I'm going to allow them to go first. And we'll pick a topic, and I may ask a general question even. What do you want? What's important to you to resolve right now that you want to take care of right off the bat? So he or she will mention it. I want to keep the home. I'll buy him out. And I go over there, and maybe the other party wants to keep the home. So we have some discussion to do to see which is best for, if there are children involved, do we bring them into the conversation? Of course we do at this point if we're talking about the home. But the moving party, the one who filed, is typically going to be the one to go first. And then we will start the discussion back and forth. And then it becomes a counter, recounter caucus. We're going to go back and forth, negotiate, determine. And like I said, that $5,000 from the motorcycle, we may decide, well, we'll take it out of the what you owe me from the equity of the home. So there's some bartering back and forth there that can work. So, but our goal here is really to have that written agreement. So when we have that written agreement, we write it all up or we record it sometimes on Zoom. We have this written up and it is legally binding with signatures on it. Now, if you are mediating without attorneys, I always advise we'll write it up, but I advise you to take it to an attorney to look at, because there are complications that you could not possibly be aware of, such as penalties for the division of retirement funds, which is another issue that we discuss, is retirement funds. How do we divide those? And the penalties are involved. So we need to make sure, that's why your attorneys are present if they're there, that they can look this over, that they can say, yes, I'll prepare the quadro, which is a document that allows your retirement monies to be transferred over without penalty. So there's a lot to know. So that's why we want to really make sure what you're signing, you know what you're signing, and you're in agreement with what you're signing, and you understand all the ramifications of it, because it is legally binding. And then from there, you're going to have your attorney is going to take this agreement that we've either written or created there in the mediation with signatures. They're going to take it and put it into a judgment of divorce, and it will go to the court system at that point in time, and it will be accepted, and then the divorce would be final. I hope that gives you a little bit of a flavor of what you're going to experience when you go into a divorce mediation. We call it domestic mediation. But just know these few things I do want to be sure that you know is this is not high pressure, okay? I've had people who've had to come back a second time, and that's okay. They can come back a second time. I've had people who do a partial mediation. So let me speak to that. It is possible that you do a part mediation. So you can agree on all of these 10 things, but these 2 things over here we can't agree on. So with that partial agreement, those things are off the table. They are settled, they are resolved. It's only those 2 things that have to go into the court system to be determined. And that is better for everyone. There's less to be have animosity over. So I hope that's helpful to you. Again, this is my contact information. If you want to connect with me, ask me any questions. I'd be more than happy to speak with you, to clarify. Request that booklet, Preparing for Mediation. It helps you get started. All the documents you need to collect. Lots of great information in there, and it will save you a whole lot of money because you don't have to do it in the attorney's office that you're paying $350 an hour for. So connect with me. Let me be of help. Kathy Beatty, Divorce Support Anonymous.